Welcome to the National Press Foundation. We're coming to you from the Evelyn Y. Davis Studios. I'm Chris Adams, Director of Training for NPF. Today, we're continuing our series on understanding global trade. It's the 6th of 10 that will explore how trade alliances and supply chains are shifting, how trade enforcers are trying to maintain fairness, and how workers and consumers are affected by it all. We're thankful for our sponsor, the Heinrich Foundation, an Asia-based philanthropic organization that works to advance sustainable global trade. An update on some other programs. Tomorrow, May 26th at 1:30 Eastern, we'll be continuing our series on poverty issues with a look at how Black and other minority-owned businesses have fared during the COVID-19 downturn. How have they fared? In short, not well. And how can they recover? We'll explore that with Major L. Clark III of the Small Business Administration, Patrice Willoughby of Signal Group, and Francis Murphy Draper, publisher of Afro News, one of the country's oldest African-American newspapers. Register at nationalpress.org. On our website, you can also find details on a new grant program for environmental reporting. The KOZIK Environmental Justice Reporting Grants are sponsored by the National Press Foundation and the National Press Club Journalism Institute. They will award grants ranging from $10,000 to $25,000 to support journalism focused on environmental justice and environmental racism. Today, we're thrilled to have with us 3 experts to talk about intellectual property and how well it is being protected, particularly from China. Andrei Yanku is co-founder of the Renewing American Innovation Project at the Center for Strategic and International Studies. Previously, he was Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. Elaine Wu is Principal Counsel and Director for China IP at the Office of Policy and International Affairs in the U.S. Patent and Trademark Office. She is responsible for leading a group of attorneys with expertise on China's intellectual property system. And Mark Cohen joined Berkeley Law in 2017 as a Senior Fellow and Director of Berkeley Center for Law and Technology's Asia IP Project. Cohen also hosts the popular blog ChinaIPR.com, and he previously served in IP roles at the U.S. Embassy in Beijing and at the U.S. Patent and Trademark Office. We'll hear from each of our panelists, and then we'll have plenty of time for Q&A. You can raise your Zoom hand or put a question into the Q&A text function. And please tweet today at #NPFTrade. So welcome all. I want to thank you all for joining us today. And I'm going to open it with a question to each of our panelists, who will talk about a different aspect of the China IP threat or China IP issues. And I'm going to turn to former USPTO Director Andrei Yanku, who I was hoping you could give us some terms here for what it means when we're talking about intellectual property theft. Are we talking about high tech? Are we talking about fake handbags? So if you could give us the overview and give us a sense of what the biggest problem is right now.
Sure, thanks, Chris, and thanks to the NPF. An honor to be with all of you. Look, there are multiple ways of thinking about China and the challenges it poses when it comes to intellectual property. IP theft is a broad category, and I'll go through that in a second, but just keep in mind that it's only one of the issues that China poses to the United States and the rest of the world. So focusing on IP theft, Chris, it is indeed the theft of luxury goods, but it's also the theft of high-tech goods. It's the theft of pharmaceuticals and medical products, and frankly, everything in between, and including automotive parts, airplane parts, and importantly, data. Obviously, folks are familiar with the leak of data from Equifax, where the sensitive information of something like 150 million Americans, about half of the country's population, was compromised by Chinese action. But in any event, so that is affirmative theft. So one way to think about it is, one, we have affirmative criminal action, espionage and the like, issues that the FBI deals with, and so forth. That's one category. Another category is affirmative state action that doesn't necessarily rise to the level of criminal action or espionage. So examples of that include simply the investment and acquisition by China of American industry, purchasing companies, interests in companies, and therefore purchasing access to their technology through the open market system. Another type of affirmative state action is talent acquisition, where the Chinese government goes out and recruits American scientists, engineers, computer programmers, and the like. They have a formal program, for example, called the 1,000 Talents Program, and they can gain access to American technology that way. Another example is the forced technology transfer. So American companies, for example, doing business in China, being forced to disclose their technology, sharing their technology with a Chinese entity in exchange for being permitted to do business in China. So those are affirmative state actions that the government is involved in. A third category, which is critically important, is counterfeiting and the insertion into the stream of international commerce of fake goods. The OECD estimates that over $500 billion in international trade is being diverted to counterfeit and fake goods. The estimate is actually difficult to make, and most likely the number is much higher than that. But in any event, it's even at 500 billion, it's very substantial. And according to the OECD, almost 85% of that comes from China and its territories. To put things in context, the next offender when it comes to counterfeit goods is Turkey at 4%. So that puts a bit into context the Chinese impact on the commerce of counterfeit goods. 25% of the intellectual property infringement through counterfeiting is against U.S. intellectual property rights owners. So these are some of the categories that broad-based categories that we are facing, and there are problems across the board, and the United States and our trade partners need to address, and we are addressing. I want to emphasize, though, that it really is important not to dismiss China simply as a pilferer of intellectual property. China is also an impressive originator of intellectual property, and for sure, they do pose very significant problems with respect to theft of IP. But at the same time, they have focused in recent years on developing technology on their own, and they have made very significant progress in that regard. And it is really important for the United States to attend to that, pay attention to that as well. I'll give you a couple of examples, statistical examples, just to put things in context. At this point, China generates on an annual basis at least 3 times as many patents as the United States around the world. Now, some folks say, well, those are not quality patents, and there's all kinds of issues with them, but nevertheless, it is one statistic to keep in mind. In addition, China publishes more articles in peer-reviewed scientific and technical journals now than the United States. China graduates significantly more, multiple times more, PhD scientists and engineers and computer scientists than the United States on an annual basis. And China now is pressing against the United States on leadership of standards bodies around the world. So in every category that we look at, China is making progress when it comes to science and technology development, in particular with respect to the critical technologies of the fourth industrial revolution. So we can talk about this some more, but it is really important for the United States to realize that we are facing very significant competition. And if the US is to maintain our technological lead, for the technologies of the future, then we must attend not just to China's theft of IP, but also to our own internal development of technology here within the United States proper. So we'll talk a bit more about that, but let me just stop there, Chris, and hear from the other panelists as well.
Okay, so I'm going to turn to Elaine in a second here, but first I want to just run Christopher Wray's quote. This was from last year, but he and the FBI have said similar things this year. Last year, when he was talking about China IP theft issues, he said, quote, "It's the people of the United States who are victims of what amounts to Chinese theft on a scale so massive that it represents one of the largest transfers of wealth in human history." He was talking about the theft of personal data, data that could harm national security, and data that relates to intellectual property. I'm just looking for a kind of a gut check. That phrase, one of the largest transfers of wealth in human history, is that, do you buy into that? Does that feels like hyperbole, but what are your views on it?
Yeah, look, I don't have at hand the numbers year by year that can be measured. It is definitely something that can be measured, but I, at the gut level, I believe that is true. It has to be true. The level of counterfeiting that's going on right now, the level of access to our data, and the data transfers and breaches that are taking place cumulatively, simply because of the scale and the annual growth, has to be more than in the past. But frankly, Chris, I don't personally have the actual statistics, but it feels correct.
Okay, well, thank you very much. So let's turn to Elaine Wu right now. Elaine, your office tracks China's IP system. And so I was hoping you could give us an overview of how it functions, how it compares with the US system, and how things have changed with China's IP system in the last few years. So I'll turn it over to you right now. And you have a slide deck. So Jeff, if you could pull that up for us.
Great, thank you. So I want to, thanks. So thank you very much. I want to thank Chris and the National Press Foundation for inviting me to speak today, and very happy to be on such a distinguished panel. So yeah, I do want to talk about some of the key IP challenges and developments in China that we hear from our companies. So let me talk briefly about that. And so next slide, please. So the three things I want to talk about is what are the major IP problems? I'm going to really focus on problems concerning technology, safeguarding technology. And Mr. Yanku kind of alluded to that earlier about forced tech transfer. So I'll just touch on that very briefly. Also talk about some of the patent protection and trademark protection issues that we are hearing about. Also talk a bit about enforcement, IP enforcement in China, how it's improved or not improved. And I have a few key takeaways that might be useful that I want to leave with everybody. So next slide, please. Just a word about forced technology transfer. I'm glad that it's been discussed. The issue of forced technology transfer is actually was the basis of the Section 301 investigation that the last administration launched against China, which eventually led a couple years down the road to the US-China Trade and Economic Agreement, their Phase 1 agreement, which has a large intellectual property chapter. I'll talk about that very briefly. We're in the process of implementing that intellectual property chapter as we speak. But some of these forced technology transfer issues have remained. They hopefully with the agreement, we'll see how the agreement pans out, how it's implemented. Several provisions were related to forced technology transfer. So I just want to touch on that. That is a very big issue, and that is really at the heart of some of the Section 301 investigation and also the agreement. But let me switch now to protection issues. And I have a slide up that really talks about China's Trademark and Patent Office being the largest patent office in the world. It is called CNIPA, China National Intellectual Property Administration. And Mr. Yanku alluded to that earlier about patent filings. I want to talk about both patent filings and trademark filings and give you some statistics. So you can see from the slide that in 2019, actually, I should have 20, I don't know. I don't know if you see 2020, I don't see that. I should.
Yeah, 2020 is on there.
Okay, good. I didn't see that. So you can see that in 2020, China received a huge number, 9 million some trademark applications. And that was a 19.3% increase from 2019. Huge numbers. Next slide, please. I want to do a quick comparison for China trademark filings compared to the other large trademark offices in the world. They include the Japan Patent Office, the Korea IP Office, the European IP Office, USPTO, and CNIPA are part of that mix. And you can see China on the bottom line, way ahead of the rest of the other trademark 5 offices, the rest of the large trademark offices in the world. Next slide, please. Now, CNIPA receives 8 times as many patent applications at the US Patent and Trademark Office. US Patent and Trademark Office is a very large office. But China receives 8 times as many. And you can see, again, from the statistics in 2020, more than 5 million patent applications. Next slide, please. Now, comparing CNIPA filings with the other large patent offices, these are called the IP5s. Again, that's the European Patent Office, Japan Patent Office, Korea IP Office, CNIPA, and then US Patent and Trademark Office. Again, you can see in yellow the numbers at the China trademark, the CNIPA. These are numbers of invention patents. This is one of 3 patents that China issues to applicants, and that number is very large. Next slide, please. So USPTO recently issued in January of this year, issued a report entitled Trademarks and Patents in China, Impact of Non-Market Factors on Filing Trends and IP Systems, to address these large number of patent and trademark filings and possible impact on the USPTO and US companies. And the report finds that beyond the usual market factors that drive such applications, a number of non-market factors influence Chinese filings. Non-market factors such as subsidies, government measures, and several other factors like that, but mainly subsidies and government and mandates, subsidies, measures, and government mandates. And these non-market factors have contributed significantly to these application trends. The large numbers have actually an impact on US companies and also on USPTO and other offices, including China's office, of course. It has affected the USPTO capacity of USPTO trademark examiners because of the large numbers. It's stretched the capacity of China's patent and trademark examination systems. It's cluttered China's patent and trademark registries, which then makes it complicated for US companies to do clearance searches and to seek protection in China for their patents and trademarks, because they have to do, for example, do a lot of complicated and expensive freedom to operate analyses to make sure that their patent that they want to apply for does not infringe on another patent, for example. So this complicates things greatly for a lot of US companies. And so we're watching that very carefully. The interesting thing is that about 2 weeks after the USPTO published this report, CNIPA did issue a notice that basically said that it would eliminate all local patent subsidies and awards. And just 2 weeks ago, we heard that CNIPA issued another measure to eliminate local trademark awards. So we are watching that very closely to see if that affects anything, to see if it affects these large numbers. And so it's kind of interesting that China has decided to do that very recently. China has also issued some measures about abnormal patent applications, all in an effort, we think, to deal with these very large numbers, which is also a problem, of course, not only for foreign applicants, but for domestic applicants in China too. Next slide, please. Moving on to enforcement. Is there a slide missing? Sorry, was there a slide just before that? Okay, I'm sorry then. All right, so moving on to enforcement. I did have a slide earlier, and I kind of wanted to mention this, that while the enforcement system in China is still problematic, China is actually one of the most IP litigious societies in the world. And I did have a slide that basically said that China had 480,180 first instance civil IP cases in 2020, as reported by the Supreme People's Court of China, which is a mind-boggling number compared to a lot of other jurisdictions. So while there are lots of enforcement problems in China still, China is in a particularly litigious IP society, particularly when it comes to copyright cases.
Yeah, that's actually the next slide. So Jeff.
Oh, I'm sorry. Okay, I
one
flipped
more.
it. Got it. Yeah, I'm sorry. Thank you very much. I think I flipped it in there. So yes, thank you. This is a slide that basically, contrary to what a lot of people may speculate, that IP enforcement is such an issue in China. It is really actually a spectacular IP litigious society, and this is the slide that I just mentioned, according to a recent report. So going back to the other slide just now, China has a two-track IP enforcement system: administrative enforcement, primarily through the State Administration for Market Regulation, or SAMR, and judicial enforcement, both civil and criminal. I wanted to mention, touch on judicial enforcement very briefly, that China has recently established several specialized IP courts in Beijing, Shanghai, Guangzhou, and Hangzhou. It has established several IP tribunals throughout the provinces and cities and municipalities. It also established internet courts in Hangzhou, Beijing, and Guangzhou, and most recently at a national appellate IP court within the Supreme People's Court, which is the highest court in China. This is to say that China actually has made great strides recently and last several years to try to improve its judicial enforcement system for IP. Next slide, please. Next slide after that. But enforcement issues still remain for China. If you would just click on, I think the bullets will appear. Yeah. We hear from rights holders difficulties establishing cases because it's very difficult to collect evidence, very difficult to introduce evidence to the court. High risk, low reward. A lot of rights holders tell us, well, it might not be worthwhile enforcing the rights in China because the cost, while the cost is not high, particularly it's the damages that one receives for enforcing their IP in China is very low, although they are increasing. And so the question is it worth it in the end? Diminished private right to enforce IP because of a renewed interest, particularly in the patent area, renewed interest in enforcing IP through administrative enforcement. Inconsistent application of the law, meaning that if you are trying to enforce your IP in certain provinces in China, there may be what's called local protectionism, protecting the Chinese party as opposed to Chinese party, and then putting the US party at a detriment because of protections at the local level. And then now infringers are using new methods and technologies to counter some of these enforcement efforts. Next slide, please. So just a couple of key takeaways I want to leave with everyone. As far as the Phase 1 agreement is concerned, in recent years, before the Phase 1 agreement, and particularly afterwards, China has taken steps to enact or amend 60 plus IP regulations, including amendments to the patent, trademark, and copyright laws, and numerous judicial interpretations, implementing regulations, examination guidelines, and so on and so forth, as part of the Phase 1 agreement. It is very unclear right now how China's courts and agencies will implement and enforce these new regulations, particularly at the local level. So we expect rights holders in China to continue to report that these problems will still persist. Chinese offenders are becoming adept at new methods of countering these enforcement mechanisms. Some of China's new approaches to address IP may actually raise more new problems, and particularly on enforcement at the administrative level and so on. And then, of course, as our report shows, the large volume of trademark and patent filings clogging the IP system at CNIPA, and also foreign IP registries, not only USPTO, but others, can be problematic and can distort IP filing activity. I want to end by saying that I think Mr. Yanku is exactly correct that China is, I'm sure that many of these patents that China's filing are innovative. And we know that for a fact. However, we have found that the clogging of the system also is problematic for a lot of our rights holders because of the numbers. So thank you very much.
Okay, so thank you very much. And the report that you mentioned, we will include a link to that in a series
great.
of resources that we post on our website later today or tomorrow. So all the viewers will have access to that report as well as some other reports, speeches, articles, and things like that. So I want to turn to Mark Cohen right now. Mark, you've been watching Chinese IP issues for years, and you've been watching coverage of those issues. I was hoping you could give me a sense of how well you think the media are covering the issue. And are they getting the nuances and understanding, what IP is and what IP theft is? So I'll just turn it over to you for a few minutes, and I'd like to get your perspectives on that.
Thank you, Chris, and it's a pleasure to be here with you, NPF, and my distinguished colleagues at the PTO and former colleagues. So I think that actually Andre and Elaine gave me a good point to tee off on, which is how inward-looking the Chinese IP environment is. We talk a lot about IP theft and the threat to the U.S. economy, to the global economy, forced technology transfer, the like. And most people are unaware of those 450,000 or so cases that Elaine pointed out. Less than 1% have a foreigner. Of those 9 million or so trademarks, probably 85% or more are Chinese-only applications, not foreign applications. Of the utility model patents, less than 1% are filed by foreigners. Designs, less than 1%. You have an environment that is overwhelmingly inwardly looking, and juxtaposing the language we hear about the threat that of China and how bad the enforcement system is. We also have to figure out, why is it such an active system? Why is it the most litigious society in the world? Why is it 10 times the size of or more than the US Trademark Office and the US Patent Office? Why is it that foreigners utilize it so little and we complain about it so much? These are really the enigmas of the Chinese IP environment. So it's only focus on the problems, and I'm not diminishing those problems. So don't think of me as a panda hugger, that the Chinese system is wonderful and everybody should go there and file more patents and trademarks. You'll always be treated fairly. I'm not saying that, but we've obscured a lot of the nuances, the important information about where the main points of threat are, where are the real problems. Take trade secrets, for example. The US files maybe a dozen or so criminal trade secret cases per year. I don't know how many percentage of those are Chinese. China files very few cases. This is a very seldomly litigated right. It's really entered the focus of US attention. I believe last 2 years or so, there were about 5 civil trade secret cases involving Americans in China, 2 of which involved Americans as defendants, not as plaintiffs, as someone who was accused of stealing trade secrets from China, rather than someone who was a victim of Chinese trade secret theft in China. So it's actually a pretty complicated environment, and there's a lot we don't hear about. Part of the problem, I think, with this is the US media, in my estimation, tends to be considerably less expert on Chinese IP issues than the Chinese IP media. That's not to say that the US media is getting the story right or wrong and that China is getting the story right or wrong. It's just that, in my view anyway, in general, I think that the Chinese tend to get the facts right and the story wrong. The US tends to get the facts wrong and the story right. It's kind of an odd situation, but just to give you an example, if you could pull up my slide, just on reporting on a big case involving Michael Jordan. I think it was 5 or 6. Page 5 or 6.
Yeah.
Okay, so here you go. Michael Jordan happened to have won a very big trademark case in China. It was a case that went on in its various forms of dispute for perhaps a dozen or so years. The US media couldn't get it right. Was it a copyright suit? Was it a name right suit? Was it a Chinese trademark battle? I just pulled these off of Google a few days before this presentation because I knew they got this one wrong. And if you look at the Sports Illustrated, the top one, Michael Jordan wins copyright lawsuit. Next line, comes out victorious in a trademark case. Which is it? US media is notorious for conflating, not discriminating patents, trademarks, copyrights, forced technology transfer, software piracy, copyright piracy, all these things have gotten commingled. And it would be good if we began to tease them apart, particularly journalists who are in fact very dependent on copyright protection. So it's kind of surprising that they would get it wrong in terms of Michael Jordan. And you could see in the next slide how ultimately Sports Illustrated had the meta tags to say it was a copyright case, but probably somewhere along the line, the editor said, you know what, that wasn't a copyright case. That was a Michael Jordan brand. It was a trademark case. And they corrected that, but not the meta tag. So that may seem small, but actually in the grand scheme of things, it's problematic because I think US journalists have the ability, if not the obligation, to really ferret out the facts. We should really be as demanding in intellectual property as you are in any other area, political or otherwise, to get down to the meat of the cases and not just rely on the surface, and certainly not to get the big pictures wrong. So if you looked at this issue of IP theft in particular, you know, there's the term has tended to conflate a lot of issues. I mean, Chris raised the point you just raised about the $600 billion. I think that went back to Dennis Blair, the largest theft in American history. Admiral Blair on the National Commission to Stop IP Theft, a distinguished man, but not the guy you would go to file a patent for. I mean, he's a guy who came out of the military, and the FBI is generally a police organization. You want to know about patents, you can turn to Andre and Elaine. I'm not even the patent guy. I deal with IP more generally. I'm not admitted to the patent bar. So the number was probably, in my estimation, a bit exaggerated. It relied on some OEC data that was revised, but that was exaggerated and gross. There were probably things that were omitted and things that probably should have been added to the data. Most importantly, when we talk about theft, we have to realize that if you look, for example, at Elaine's data, IP is a civil right. It's a civil remedy. 460,000 civil IP cases in China, a ginormous number. How many criminal cases in China? During that time period, I'm going to guesstimate 8,000, which, by the way, is huge compared to the 100 filed by the Department of Justice, but still is a fraction of the number of civil cases. So theft also kind of obscures things. In fact, patent infringement is generally not protected by a criminal remedy in the United States nor in China. So if you're talking about technology issues where people can have actually legitimate bones of contention about whether they're infringing or a patent is novel or something is a trade secret, there tends to be a lighter touch on using more aggressive remedies, particularly in the US where we don't have a criminal patent remedy. The other thing that I think is really important, and I think Elaine helped to bring this out, is that you know, China is a big data country. We may not like the data, but it generates an enormous amount of data. It's a planned economy. It's a planned economy for intellectual property. And that was the heart, I think, of the Section 301 investigation about one particular industrial policy made in China 2025, a 15-year industrial plan. That means they're highly dependent on data. They sometimes get it wrong. They sometimes get it right. But the data also really does help illuminate some of the issues that are in the Chinese IP system. And for example, I think perhaps might be a good time to bring up my slides on win rates.
Okay, and we need to move on fairly quickly. So if you could just touch on the win rates quickly.
I'll kind of conclude on this. Next, continue down. No, continue. Okay, so just to pause for a second, we all hear that you can't win an IP suit in China as a foreigner, okay? You have to justify that with China being the most litigious society in the world. So is it only Chinese that win lawsuits in China and not foreigners? That could be a big problem. In fact, the data over and over again, and I'm not saying I totally agree with this data, but I feel obliged to report out the data, shows that foreigners win in China in every right I just mentioned. And not only that, they win at a greater rate than Chinese. And then sometimes they win at a greater rate than if they were to litigate the same right in their home market. So on this slide, you see from a PhD dissertation that the win rate for patents in China was significantly higher for foreigners, 80% versus 60%. I believe that was 2014. In another report done by another academic, Brian Love, at Santa Clara, you also see a much higher win rate, including higher availability of injunctions and higher damages in patent litigation. And he tried to show that there was not an effect of domestic influence. Next slide. Okay, and just to bring this over to other rights, in copyright, where we hear so many complaints, and it was in the trade war, and I'm not saying that Microsoft doesn't have problems, but if you look at their win rate in civil litigation for a multi-year period, it was 100% for every copyright lawsuit they brought in China. Okay, Siemens was also 100%, Autodesk 100%, Dassault 100%. And in trademark, similarly, another right, a very high win rate, depending on the location. These are 4 separate studies, 4 separate people. Another fellow, Max Goldberg, who's now at Yale Law School, showed that in 1 year, in 2015, in one court in Beijing, foreigners won 100% of the civil IP cases. But there's a problem with the data. I just want to close out on this. If you go to the next slide. No, continue, I'm sorry. Next slide. Okay, no, next slide. There you go. If you just pause over here. The problem is what is being reported, how it's being reported, what is omitted. You know, if you just think of the pictures on Red Square during the period of the Soviet Union, who was missing from the picture is always the most important thing when you look at communist economies. So what data is missing from these studies? What do we know of the big, important US companies? What do we know about patents and artificial intelligence or 5G, et cetera, whether foreigners and domestic parties are treated equally? One of the big casualties of the trade war that was not reported anywhere was simply publishing cases involving foreigners. So again, no one mentioned this, but this actually has a lot to do with our ability to monitor what China is up to. You'll see that beginning January 1, 2018, this is a chart of foreign-related IP cases in China. The publication flatlines. Transparency ends over the court cases. I'm not sure if it's picked up yet or not. We really have to go back and look at the data, but this is a civil right. This is, our companies need to know how their rights will be protected. They need to know the weakness and strong points. Policymakers need to know when the system is working well. There's nothing wrong with that. We applaud that. But we also need to know about those areas where it's not working well, which is often not reported at all and is frequently the most problematic. So this is not an easy area to report on in many respects, because you're reporting on in many respects, a non-market economy dealing with a right that is governed by market principles. And you have to try to ferret out the data and cut through the smoke. But I do think the more we do that, the more we'll have a more nuanced view of the kinds of challenges that the US is facing and our companies. Thank you.
All right, so thank you very much. So we have time for questions. I have a question for Elaine Wu and then one for Director Yanko. And if you have a question, you can raise your Zoom hand and we'll turn the microphone over to you, or you can just submit it in the Q&A text function. But Elaine, Mark was talking about how companies, have a right to know whether their rights will be respected in other countries, in China. Can you give us a sense of how the business community sees the China's IP system, and has their view on it changed over the last few years?
Right. So, so the U.S.-China Business Council, the American Chamber of Commerce, and so on, which are trade associations, they do surveys about the IP environment in China. And in fact, I think there was a recent one, American Chamber of Commerce came out very recently with a report. And my understanding anyway from the initial reporting is that they definitely mentioned that Chinese courts have improved in terms of disputes in IP. This is from the American Chamber of Commerce Policy Committee head, Lester Ross, who Mark knows well. This is in a report that during a reporter's call. American Chamber of Commerce also found that over the past year, 47% of its members said enforcement of IP in general has improved overall. Mm-hmm. We also have heard from the U.S. Chamber of U.S.-China Business Council that a survey in February of 2020, and they said that that China made at that time anyway, significant commitments to the Phase 1 agreement that address many key challenges and are favorably viewed by rights holders. They also said that about, I think it was the Shanghai American Chamber of Commerce also said that 58% of companies in the pharmaceutical, medical devices, and life science industry thought that Phase 1 was helpful. Now, of course, the devil's in the details, but I think that on a broad scale of things, I think that things are rights holders. We have heard from rights holders that the enforcement system has improved, particularly with the IP courts, notwithstanding Mark's points that the use of the system is not high. I mean, most of the use of the system is, of course, with domestic companies. So that's that. But we also hear some sort of troubling statements from, for example, Xi Jinping, who recently announced in a magazine called Qiushi, which is the magazine that is that's basically a party magazine. And he's kind of made some troubling statements tying IP with China's national security, which is perhaps one of the first times that China has talked about that he has made these statements. He has also made certain statements about IP in general, about the importance of diminishing the stranglehold on IP because China is over reliant on foreign IP, and also the interest in China for it to become more reliant on Chinese IP, something we've heard for a very long time, although this comes out from a very high level. So I think I think at the end of the day, these statements, we should be aware of these statements. We should be watchful about what these statements mean. We should see what it means with US rights holders. Is it going to be more bias against US rights holders, particularly US rights holders and companies that have a technology that China finds very important for its development? And so I think those are the things that we have to watch out for, despite the fact that at the end of the day, American Chamber of Commerce and a lot of other trade associations have said overall that when it comes to IP enforcement, it seems to have gotten a little better, certainly in the last few years.
So big picture, it's gotten better since the Phase 1 enforcement measures were put into place, but now you have concerns about the statements from Xi Jinping?
Yeah, so I would say that I don't know, we don't yet know about implementation of Phase 1. I mean, the US-China Business Council and American Chamber of Commerce had said initially that they thought that Phase 1 had done some good, but really at the end of the day, I think implementation is key. And so right now we don't know what's going to happen with the Phase 1 in this administration, but we are in the process of implementing what we've already started. So, but so really the devil is in the details, and we'll have to see what implementation will hold, especially at the local level. But their general sense is that at that time anyway, that they had some favorable views, and then that the American Chamber of Commerce just recently reported that when it comes to IP enforcement in general, particularly the courts, there seems to be some improvement.
Okay, so I want to go back to Director Yanku right now. I want to ask you a couple of kind of big picture questions. One is on politics, and then the other is on kind of what comes next. Can you give me a sense of how different the Biden administration's views on this threat are from the Trump administration's views? And how differently is the Biden team going to respond to this than the Trump team did? And just in general, what should the government and what should corporate America be doing to help lessen the threat that exists?
Yeah, well, first of all, let me add to what's been said already, that the intellectual property challenges from China are extremely broad. And what Elaine and Mark and I have been talking about here for the past half an hour, 45 minutes or so, really are just some examples. There are many other areas that we must attend to. I'll give you another very quick example here that is super interesting, and it's somewhat flying under the radar in the general press, and that is access to standards-based technologies. So you can think of a standard-based technology as 5G, for example, right? It's an international standard on which we must all get on so that we can communicate. There are lots of standards like this. Countries that control the standards can control more aspects of those technologies and therefore take leadership roles in those technologies. Well, I'll give you an example of what China has been trying to do. A Chinese court in Wuhan, of all places, has decided that it is the worldwide jurisdiction for adjudicating the infringement of standard essential patents. So the Wuhan court has decided multiple times to enter anti-suit injunctions that, in their view, would apply worldwide. And therefore, a company trying to enforce its United States patents in a United States court for alleged infringement on United States land, according to the Wuhan court, would not be able to proceed with that case because of an injunction issued by a judge in China. Obviously, so they've also entered an injunction that would apply to India in a different case. Both the Indian and the United States courts have said by and large, we're not going to listen to the injunction from the Chinese court. But you can see how far and widespread their efforts go to take leadership roles in international intellectual property ecosystems. And there are many other examples like this. So now to your actual question, first question, Chris, how do the two administrations, how will they respond to this? I really cannot comment on what the Biden administration will do. And I don't have any insights that on that the public doesn't have. In the past administration, obviously folks know about the many actions we have taken through trade negotiations and the phase one, and trying to apply pressure in such that China reduces or stops its illegitimate IP offenses, such as counterfeiting, such as forced technology transfers, and the like. Usually these are not partisan issues, so we'll see how the Biden administration responds to these same issues. It's early days, and we need to see what happens. I will say that I was troubled by the administration's suggestion just a couple of weeks ago that the US would be willing to entertain the concept of a waiver of intellectual property rights when it comes to COVID-19 technologies. Such a waiver, I have said publicly recently, would not serve its intended purpose. All of us want to distribute more COVID-related medicines and vaccines and so on around the world as quickly as possible. The question is how. Waiving IP rights, I think, will have the counter effect, and in fact would tend to slow down not just innovation, but also the transfer of those technologies across the world. Intellectual property is usually the solution. It enables companies to collaborate with each other, and we have seen that here with hundreds of voluntary collaboration agreements. So this step has, the suggestion that we would agree to such a waiver is unprecedented. Now we'll see what happens. Again, early days. It was just a public statement. We'll see what happens in the negotiations at the World Trade Organization down the line. Finally, very quickly, in terms of what does industry have to do in order to address this? So first of all, governments have to work, the US administration with our allies, we have to work to slow down or stop the bad actions from China and try, such as the counterfeiting and economic espionage and such. But in addition to that, we must focus as a nation positively inward at our own technological development. We must get more Americans, more folks here in the United States to innovate. We must expand innovation Demographically, we need more women inventors. We know we need more minority inventors. We need a lot of more inventors from traditionally underrepresented communities. We need folks from across the United States geographically to get involved in the innovation ecosystem. We need more hands on deck is the bottom line. We need more investment in research and development and other such actions so that we within the United States can up our game when it comes to innovation, because ultimately we cannot compete with China on the number of people. And they're also a concentrated dictatorship, a communist system, basically, that can dictate where its attention, economic attention, is focused. So we need to be able to rise to the occasion and compete within our system. And for that, we need more resources, more folks involved in our ecosystem.
Okay, so thank you. So I have a question for Mark here in a second, but for the journalist on the call, I see we have some journalists who are up very late right now from the South China Morning Post and from Japan's largest paper. So if you guys want to ask a question, I'll put you first in line. So if you want to, the journalists from Asia who are there late, let us know if you want to ask a question. We thank you for sticking around so late at night for you. But Mark, I want to go to you with the same politics question. And can you just give me I know it's not a simple question, but a fairly brief assessment about whether the Biden administration perceives the threat the same way that the Trump administration did? And if not, I mean, how might things change in how they handle it?
Yeah, so I think, as Andre pointed out, I think there's a pretty broad bipartisan consensus, certainly on the Hill, about the threats posed by China. It was evident in the National Defense Reauthorization Act and dealing with things like export controls and investment restrictions, and a lot of the rhetoric and also the confirmation hearings of Catherine Tai and others to date. Of course, the real question is how actions might change. We're in the middle of phase 1 implementation, which I think has been rather non-transparent in both the Trump administration in its negotiation and implementation, and thus far in the Biden administration. And I think there's a need for much more open consultation with industry. There's a lot of issues that were orphaned or not discussed in the phase 1 agreement. I agree very strongly with Andre's assessment that this is a complicated, multi-dimensional issue, and it would have been impossible to capture everything in phase 1. For example, a glaring exception is antitrust. Another one is the judicial weaponization or IP or judicial sovereignty issue that Andre talked about in terms of anti-suit injunctions. There's a lot looming and a lot has changed. What I'm troubled by actually is kind of a systemic issue that both administrations shared, which is the difficulty of getting really the granular IP policy at a high level within the White House. We have Catherine Tai, an immensely capable trade negotiator, as USTR. She's declined to appoint the deputy, which is authorized by law, on IP and innovation. We have to have an IP ombudsman advocate in the IPEC, the IP enforcement coordinator in the White House. And it will probably be another several months before we have a director of the USPTO, the successor to Andre Iancu. So, I mean, all of that means that the granular discussion about how technology occurs, what is a patent, what is the threat, what does it mean to have this rapid ramp up in patent and trademark filings from China? What do we do about judicial sovereignty and attacks on the US legal system from the Chinese courts? May have to wait until you have a director at the PTO, for example, who also has the ear of the Secretary of Commerce. That's a shared institutional problem that we have because the director is at the undersecretary level and the head of USTR is a cabinet level official. And it's frequently hard to get through the noise, some of it political, some of it well-meaning but ill-informed around some of these issues. I think the Biden administration has more aggressively, I think, embraced some of the issues around industrial policy and is trying to get bipartisan support in the Hill for some of the issues like around semiconductor and supply chain fragility. And hopefully that will continue and continue to have bilateral support. But there's plenty of room here for people to become heroes. There are so many issues, and if we can only make progress on a few of them, I think we'll all be very gratified by that. So thank you.
All right. So I do have a question here from Allison Shelley of WebMD. I'm not sure who to, I'll pose it to all three of you, but just a general question. Has the COVID-19 pandemic aggravated the challenges? I guess, for example, has it changed the way IP administration has been handled in China over the last year? Has things slowed down? Any sense from any of you about whether COVID's impact on IP administration?
I think, and Elaine and Andre would know better than me, but I think there was some impact in the US on patent filings in terms of provisional patents going up and perhaps utility patents going down. I think China also had some migration during the pandemic to some of the easier patents to file, the ones that don't go through substantive examination. China is probably a little bit better equipped in some respects than the US. They have their internet courts, you can file online. And so they migrated pretty quickly to different kinds of internet-based ways of prosecuting and protecting IP. I think for me, it's going to be quite interesting to see in the long run whether all this shelter in place has affected collaboration and what that means to kind of complex technologies, their development, their implementation in both the US and China, and whether perhaps the US has been put at a bit of a disadvantage due to our extended shelter in place.
Okay, Elaine, you had numbers up through 2020, but is there a full accounting yet of kind of how the numbers have changed because of
Right. So I do have numbers up through 2020, and there was a 19.3% increase in trademark filings from 2019, and it doesn't seem to. We haven't done a really deep dive yet on some of the patent numbers because I think Mark is probably correct that there may have been some increased filings of utility model patents and design patents, which don't require substantive examination, and they're just easier to get. So, but the trademark numbers are still pretty high. So we still have to parse out those numbers a little bit. There was a slowdown in reporting. So CNIPA for a while, towards the latter part of last year, kind of stopped reporting on some of the numbers. And so we're trying to figure out what that was about. And of course, as I mentioned, also there seems to be an interest in dealing with the volume of filings by, eliminating the subsidies and with some regulations on abnormal patent filings. Basically, if you file certain applications that are obviously, or and I don't want to use the obvious term in patent law, but seem to be copies of applications, then that's considered a normal application, and then you're going to have trouble getting that through. So still, we're still looking at some of the numbers and parsing them out a bit.
Okay. A question. This is going back to you, Elaine, and Andre. This is also something you touched on. Elaine, your numbers showed that China's National IP Administration received 8 times as many patent applications as the USPTO. China's roughly 3 times bigger than the US population-wise, but there's 8 times more patent applications. I realize it's kind of a crude measure, but why do they have 8 times more? How much of that is a reflection of much more innovation? How much is a reflection of just the way that they handle patents there?
Well, so let me just start real quick, and then Andre, you can jump in. Just really quickly on patent applications in China. So they issue 3 types of patents: invention patents, which is very similar to utility patents, the patents that I think everybody knows about it at the US. And then they also issue utility model patents and design patents, which we had kind of mentioned. Those are not substantively examined. At least they go through a preliminary examination, not a substantive examination. So when we look at those numbers, we're looking at all those numbers. So it is a little different because of the USPTO, we examine all our patent applications. We do not have utility model patents. We have design patents and utility patents. We examine everything. So utility model patents and designs, it is easier to get them through the system. The numbers are usually high because a lot of small businesses and companies especially file them. Invention patents are going to be a lot more difficult to get because they're substantive examined. So we have to compare apples and oranges. So there's a little difference there. As far as the question about, which of these, is there true innovation coming from China? There is no doubt true innovation coming from China. And as Andre had said earlier, but this is not to say that there isn't, it's just that as the report shows, the numbers don't necessarily reflect all of that, because a lot of the numbers are skewed because of subsidies and also other factors that are very different than a lot of, for example, in the US, which we don't provide. And so that's the whole point, which is that a lot of that is also being fed by these non-market factors. And so that means a lot of them are going to not be as of high quality as, for example, other countries in which we examine all patent applications. And I think that's the point that's to be made in that report. So.
Okay.
Chris, just to add
sure.
quickly on that, we have to keep things in context here. Only about 10 years ago, the number of Chinese patent applications, both in the US and around the world, was undetectable on the various graphs that we would have of countries stacking up in their application. You couldn't find China on the chart. It was close to zero, or low single digits in terms of percentages, and now they lead the world. So keeping things in context on the trademark side, and this goes a little bit to Allison's question about COVID-19. On the trademark side, in 2020, there's the explosion in trademark applications at the USPTO is driven primarily by Chinese applications. 2/3 of the growth in 2020 of trademark applications at the US Trademark Office come from China-based applicants. About 25% of all trademark applications in the US in calendar 2020 came from China. Compare that to about 11% in 2017 and just 2% in 2014. So we got to keep in context both the overall growth, explosive growth in the past decade, both on patent and trademark applications, and in particular, accelerating growth in the most recent years, including a COVID year.
Okay. All right. Well, we are it's 1 o'clock on the East Coast now, and so we are out of time here. I want to thank all three speakers for giving your time to us and to the journalists who are on the call. I want to thank the journalists who came on the call, as well as others, and particularly the journalists, as I said, who stayed up late in Hong Kong and Beijing and Tokyo to watch. We will have full resources from this session posted to our website later today or tomorrow, including a full interactive transcript, as well as other resources such as the report that we mentioned earlier. And for Mark Cohen, Elaine Wu, and Andre Yanku, I want to thank you once more. And for our viewers, remember tomorrow we have our program on Black and minority-owned businesses and how they fared during COVID. You can find the registration for that on our website. And then I will see you online next time. So thank you very much.